Well, you mean online media models, right? There are about five models which have been developed. For example, in Slovakia, we have developed model which can be called like cooperative. Basically, there's some media houses joined forces and decided to establish model which would be paid by readers. Basically, that they would pay a certain amount. But there are some other models that you have content for free, totally for free, which was the original model, which but doesn't work because people don't want to pay for content on their own. Then there is a model, for example, that some media houses for online media, for part of the content is free and part of the content you have to pay, like premium content. Then there is, for example, a model that everything is paid, like there is a wall, you have to pay and subscribe individually. Then there is a model that you have certain amount of articles for free, but then after that you will charge. This is actually seems to be functioning in the major media like New York Times and some others, but not in other countries. So it's also country dependent. So there are these models which are actually well known, like 4 or 5. But as I said, experiences are different, and we cannot say that we have all the business model has been successfully found. And I think the publishers or online media are still in search of a successful business model.
So everybody are talking about the new media, new online media services and so on. How would you define them, and what is the proper regulatory approach to them?
Right. Well, I think the answers to this is quite easy because there is a very good and complex definition which was 2011, I think, at the end of 2011 by Council of Europe. And you can find there very complex definition of the online media. And regulatory model, this is a very complex issue because one is what publishers or online providers would like to have. The other ones is for example, European Commission or the particular governments would have like to. And the principle. And then there was this tradition, which also related to this conference, like internet is free, and there is total freedom. I think it was valid maybe 10 years ago, but not now. So in short, the European Commission or the European Union law in general calls for either self-regulation or co-regulation, more and more towards co-regulation. But the problem with co-regulation is that industry must be involved and cooperate. And in Slovakia, but also as far as I know in Czech Republic, they say, yes, we would like to cooperate and to establish kind of co-regulation or self-regulation, but they don't do anything at the end. And even those who argued that we need no regulation of the internet didn't understand at the end that it is the courts who intervene. Even if it is, especially if it is trans-border communication, like protection of personality rights, like libel, slander cases. And this is really what happened. And there are these famous cases and decided by 2 courts in European Union, but not only European Union, but in Europe. One is the European Court of Human Rights, and the other one is Court of Justice of the European Union. They both arguing, their arguments are based on different legal backgrounds. So basically, and the courts, these 2 courts actually, in addition to national courts, have established kind of regulatory framework for internet. And from the commercial aspects, but they touch also the other aspects, these human rights aspects, and all exclusively from the human rights aspects, I mean, European Court of Human Rights. So there was, this discussion, even protests against regulation of the internet a couple of years ago. And at the end, inevitably, the courts established some regulatory frameworks which are still developing. And today, for example, we had some speakers who mentioned that and internet is free, etc. And the media has been always free, and there is a freedom of the speech, and etc. But unfortunately, this is not the case. We have always, regulated all aspects of behavior, either by informal way or by law. So, but people don't like this idea because it sounds like censorship, whatever. But it's simply true that you have a regulation, and if you don't want to have any regulation, as it is the case, like the industry, and then somebody else has to introduce. When the government is not successful, the courts at the end intervene. So that's the point here, which is in a simple way explained, but I think that's true.
Thank you. And what do you think about network level filtering, and what are the examples of use in Europe, for example?
Yeah, that, for example, this is also not very well known or accepted, but basically some countries or governments have established, some regulation indirectly through internet providers, and saying that, for example, some areas must be blocked, controlled, like pornography. So in some countries, in France or in the United Kingdom, there are some areas which are regulated in this way. So they are blocked for children, or they have to have somebody have to give some permission, allow to some websites. This is also not very much known, and this is also related to the issue that who should be responsible for regulating, the content, whether internet service providers or the final producers. Let's say, like in the case of Estonia's famous case. So, and here in this area, some areas in some countries, they decided the internet service provider should be responsible in very special cases, which can be very harmful. For example, child pornography. So they accepted this method. As I said, this is not very well known, not very much discussed, but probably it is efficient, and probably it works in these countries. But it's really evolving area. And it's interesting also, we have discussion that all media are equal and have the same rights, like, as well as regulated. This is not true, because actually even European Court of Human Rights differentiate between television, for example, and print media. They say they create more passions, emotions, or have bigger impact, on the bigger audiences. So it's more refined, I would say, this regulation and the vision of the media, what is their impact and their role. It's not that even before the internet, it was like television and print media or even radio, they are not the same type of media, they shouldn't have the same regulation.
So are you arguing that video on internet should be regulated in different and more strict manner?
But it is already. You have different regulation of online media, right, or online video. You have Audiovisual Media Services Directive says clearly that online media have different regulation, software regulation. It depends on the countries, how can they regulate them, because, for example, in my country, we have much stricter regulation even online media than the directive requires. So it is even right that the online media have software by law and even lower sanctions or fines. They have already, of course, there is some margin, as I said, for the national governments, but it is seen, and, for example, even regulation in a sense, as I said, fines or sanctions, but also whether they have to be, have some system of evidence, for example, it's different. You have television and radio, you have evidence system. And by online media, it depends on your own decision if you're a provider, whether you want to register somewhere or not. So it's already now. So there is much, but this is maybe a question for experts, not in the public, because we don't differentiate so much, but there are such nuances.
Okay.